Good early afternoon. My name is Gary Vikan. Thank you all for coming. We've got serious business today, but I hope we don't feel too serious about it. I'm going to ask somebody to close those two doors. Thank you, Kate Fitzgibbon and Bill Pearlstein, who is not here, because they represent really the energy and the grist of what's going on. And just outside that door, who's about to close that door, is Carrie Douglas, who is the mistress of ceremonies today. So, mistress of ceremonies. So thanks to her. My name is Gary Vikan. As I said, I'm a Byzantinist. That's what I do still. For 19 years, I was director of the Walters Art Museum in Baltimore. Before that, I was at Dumbarton Oaks. And briefly, I worked for Dominique de Menil. What do they all share in common? They all have spectacular collections, none of which has provenance at all. So I spent my life being a digger in the basement and not in a trench, but formed some opinions in that capacity and also in my capacity for 3 years on the Cultural Property Advisory Committee. A year and a half ago or so, I joined CCP, the Committee for Cultural Policy. The intent of this committee, broadly speaking, is to bring the voice of collectors, museums, and legitimate dealers to the table of conversation in order that we can bring a little greater sense and clarity to what goes on in the movement of cultural property, both across borders into the United States and things that are already here and haven't found a home in public service. Because at the end of the day, unless and until we bring these objects to serve the public, we have not done our job. I'm just going to read one sentence from the mission statement of the Committee for Cultural Policy. We believe that cultural policy must be transparent, accountable, consistent, and consistent with the public benefit. So that's what we're after. Three things: transparency, accountability, and consistency. And I don't believe we have any of those in adequate measure right now. And I think many of you, no matter what your perspective may be on the specifics of the movement of cultural property, would probably agree with me. Again, Bill Pearlstein drafted about a year ago something that will be published in the Cardozo Arts and Entertainment Law Journal shortly, called a Proposal for Reform of U.S. Law and Policy Relating to the International Exchange of Cultural Property. This is a document of nearly 100 pages that, if you kind of get up to 60,000 feet, represents the landscape. We took a careful look at this landscape at the Cardozo School of Law on the 10th of April. And now we have come down to earth a bit, and the intent today is to find a roadmap to the future, ways that we can act consistent with the diagnostic toward the common goals we share in order to bring transparency, accountability, and consistency to the movement of cultural property. Again, both borders into the United States and those orphans that already exist in the United States in great abundance. With that, I've said what I shall say. I'm going to go sit down. Everybody smiling? Great. Thank you. By the way, I forgot to mention, many friends in this room, many people I've known for a long time, people I've served on the Cultural Property Advisory Committee with, plus the neighbor from across the street when my daughter was 3 years old. And she now is a lawyer. So if that doesn't tell you something, I don't know what does. With that, Timothy, was I brief enough?
That was brief enough. Thank you.
Thank you.
Knowing Gary's propensity for speaking at length and his ability to do so, I cautioned him to keep it brief, and I'm glad he did, because we have a lot of territory to cover today. My name is Timothy Rubb. I'm the director of the Philadelphia Museum of Art, and I'm delighted, as Gary said, to be with you this afternoon and with the panelists who have been assembled for this event. I'm serving as moderator today, and in that capacity, my role is indeed a modest one. Two words coming from the same root, to make some framing remarks and suggest a few avenues of inquiry at the outset, and then to prompt some questions to our panelists for their answers, and just as importantly, to ensure that the questions, or at least some of them that you in the audience have contributed, are answered. And I believe that you've been encouraged, and if not, I will encourage you to write questions down. Where do they need to be gathered, and by whom?
Let me delegate Miriam.
We're long on logistics here. So Marion, where are you? Raise your hand.
She's being brought in.
She's being summoned. But anyway, you have some paper in front of you. If you have specific questions you'd like answered by the panelists, please write them down, hand them to Marion when she comes into the room and identifies herself, and there she is. And she'll bring them up to me in due course, and I'll sort them through and pick out the most wonderful of them. So I was invited to participate in this event for perhaps two reasons. First, because I am currently serving as the president of the Association of Art Museum Directors, which obviously has an interest in the acquisition and display of antiquities and various types of cultural properties, and which for the past decade and more has been writing, revising, and promulgating to its membership guidelines for doing so. Guidelines that, in retrospect, seem to have been devised specifically to please no one at all. But we continue to do this work and do it in earnest in the hope that we will get somewhere. And secondly, because I've had the experience both of acquiring antiquities for several institutions where I've served as director, and at one of these, the Cleveland Museum of Art, the experience of going through a protracted negotiation over the request to repatriate objects from our collection to the government of Italy. Thus, my experience with the issues we'll discuss today has been, and I want to underscore this, as a practitioner, one who's had to manage the care and development of several collections, negotiate with officials from various source countries, and that work continues today and looms ever larger on my schedule and the schedule of other directors, and also deal with collectors who often have felt confused, or at least at sea, when confronted with the changing legal landscape that is the subject of William Pearlstein's excellent white paper. As such, that is to say, again, as a practitioner, I've had to take into account these same legal uncertainties, but also, and I want to underscore this, other variables as well that I think are essential to a conversation of the type we're going to have today. Some of these issues have been political or diplomatic in nature. Other variables have been about risk management. Should we do something or not, and if we do, what happens? The ethics of collecting, donor relations, and the often very powerful public perceptions regarding decisions museums make and how transparent these may or may not be. In sum, the calculus that I and many of my colleagues in the field have applied to the acquisition of antiquities and cultural property has become increasingly complex and has left us open at times to criticism and second guessing. And I want to again underscore here that the legal complexities and the legal uncertainties we face and seem to grow apace with all the others are just part of a much larger and indeed much more complex picture. So in this regard, the question of the various laws that govern the acquisition of antiquities and cultural property and their application is, of course, enormously important. But it is, for me, only one part of a much larger story that continues to unfold in many different and often unpredictable ways. And I hope that our discussion will touch not simply on legal matters, but on some of these other issues, because they have exercised a powerful influence on the application of laws and on conversations about how and for what reasons they should be amended. So we shouldn't really consider, and I know we won't, the legal issues in isolation from these other matters, because it is a dynamic equation. Now, I'd like to make two additional observations, one related to the next, before we ask our first panelist to speak. The choice of a certain date for the implementation of a set of guidelines governing the acquisition of antiquities and archaeological materials, such as those adopted by the AMD in 2003 and subsequently revised in 2008 and then in 2013, was then and remains a subject of considerable debate in the field. Now, there are those, and I count myself among them, who felt that the choice of 1970 as a threshold was appropriate, not because it had a legal basis, but rather because it was broadly accepted in the world as a treaty date. And there are others, of course, who did not believe that. It served as an important function, or rather it served an important function in the discussions I had with Italian officials some 7 years ago, it being 1970 and the concept of 1970 as a treaty date. And I believe that it will continue to serve a useful purpose in the future as we continue to evaluate the question of antiquities with incomplete provenance. The adoption of the 1970 rule in 2008 did not, however, create the problem of orphaned objects, and often the two are linked together. To be sure, it may have aggravated what one might call a pre-existing condition, but again, it did not create that problem. Now, whatever the cause of the orphaned object problem, and this is something we recognized in 2008 and have continued to acknowledge, this requires a solution. That is, again, the question of orphaned objects. This solution will perhaps require changes in existing laws, but I don't think that this alone will be sufficient. Rather, like so many of the other issues we face in the field of the acquisition and care of antiquities and cultural property, the best solution will change as well the way change as well in the way we think about these problems politically, diplomatically, and above all, ethically. This, broadly speaking, again, the question of orphaned objects and how we address it is the challenge that the museum community faces today, and I think it's one that we should not fail to address holistically. So let the talks begin. I prefer to hold my question about what our speakers, or questions rather, about what our speakers will say, and those that come from the audience until all of our participants have spoken. But if there's any point that one or another of them raises that requires some discussion, I won't hesitate to pause and address that before we move on. And so many thanks again to our panelists and for all of you being here today. And I believe that, who is the first up? Okay,
I think that would be me.
Matt
Thank you. Thank you. First of all, it's really a thrill to be here with such a group of distinguished panelists, such great names in the world of art. I'm a collector. I just need to let you know that. And together with my wife, we've collected textiles for nearly 4 decades. So I'm bringing to this conversation the perspective of a collector and one who has worked closely with museums on exhibitions, on scholarship, and on conservation. But to get right to the meat of the matter, we have a really serious problem. And anyone involved in the art market or market for cultural property needs 3 things, and Gary touched on this. We need transparency in rulemaking. We need clarity in what those rules require of people, and we need consistency in how they're interpreted and how they're enforced. And our problem is that we are not delivering on any of these. And the result is that we're driving responsible participants out of the market. If we allow this situation to continue, we're going to do permanent damage to our cultural institutions and even our efforts to preserve global cultural heritage. In the U.S. here, we've always placed a high value on the study and understanding of other cultures. We also acknowledge our obligations to be responsible global citizens, and we've looked for ways to balance our desire to provide public access to the art and artifacts of these other cultures with our responsibilities to play a role in preserving global cultural heritage. In 1983, we took a great step forward in attempting to provide a roadmap for these things. We passed into law the Convention on Cultural Property Implementation Act, which is a real mouthful, so I'll just shorten it to CPIA. And it defined how the United States could help in discouraging illicit trafficking. It also acknowledged the importance of legitimate markets and provided a template for those legitimate markets. And it gave all of us, museums, collectors, everyone, hope that we would now have clarity. Well, I think most of you know that it hasn't worked out that way. We have conflicting U.S. laws, which have sometimes been exploited by foreign governments. to undermine the intent of the CCPIA, and the requirements of the law itself are often ignored in its implementation. And the result is we've created confusion. And no one really knows where the line stands between acceptable behavior and unacceptable behavior. And with new restrictions and expanded lists of restricted materials coming, all the time, no one knows where that line will stand in the future. And this is devastating. It's a self-inflicted problem. And there have always been legal and ethical questions about what's okay to collect and what's not okay to collect. And museums and responsible collectors have always searched, for a clear set of rules to play by. But instead of offering clarity, as time has passed, we've made it more and more confusing and more complex and even more difficult to comply. And of course, we have the conflicting U.S. laws, but now we have to contend with foreign cultural property ownership laws. Some of these laws go back hundreds of years. They're mostly not written in any language that I understand. And we have international treaties that tie them all together, and an expanding list of memoranda of understanding with lists of restricted materials. But we're expecting, museums and ethical collectors to have an intimate understanding of all of this, every time they make a decision as to whether to purchase an object or accession an object. And this is clearly, it's an impossible burden. Of course, it may explain why museum legal departments are now almost as large as their curatorial staffs. A few weeks ago, there was a symposium in New York that was focused on the legal issues at Cardozo Law. I went. I was hoping for clarity. Well, let's just say it was fascinating. Really, really interesting. I listened for hours as panels of experts discussed arcane legal topics, and the thing that impressed me most is how little they agreed with each other. So I'm thinking to myself, if these experts can't agree, do us ordinary people really have a chance? And someone actually asked this question. And the panelist who was responding was a government lawyer who had tried some high-profile restitution cases, and he said, well, you just have to hire good lawyers. And I thought, what a wonderfully American solution to all problems. And he said, and also bring money, because it'll cost you $1 million at least to defend against a seizure and forfeiture procedure. That's sort of a chilling prospect. You have to spend $1 million to keep something that you thought you owned already. I'd also like to make it clear that we're not just talking about antiquities anymore that are thousands of years old, or archaeological objects that are many thousands of years old and immensely valuable. Foreign cultural property ownership laws are now being extended to cover colonial items and ethnographic materials of almost any age, extending well up into the 20th century, in some cases right up to present day. So be careful what you buy in that airport souvenir shop. Customs Border Patrol might take it away from you. And foreign governments have become very, very savvy about how to manipulate our legal system to assert these laws against U.S. citizens and institutions in here in the United States. And this really does create a chilling atmosphere. It's what I would call an atmosphere of perpetual uncertainty and, to a certain extent, fear. So it's no surprise that for museums or knowledgeable collectors who actually know what's going on, many of them are choosing to just abandon these fields of cultural controversy completely. So I said this is a self-inflicted problem, and it's one that is within our collective power to sort out. It's going to take a lot of cooperation between all of the stakeholders. It's a question of agreeing on what we value as a country, setting our priorities. Museums and responsible collectors will play by the rules if they know what they are. But if we do nothing to resolve the uncertainty, responsible participants will exit the field. Museum collections will go dark. They won't add to those collections. They won't display them. Donors will stop giving money. Funding for scholarship, conservation, archaeology will all dry up. Private collectors will quietly dispose of their collections, most likely to foreign buyers. And I can tell you from direct personal observation, all of these things are already occurring. But it raises the question, if we drive responsible participants, out of the market, does the market for cultural property just go away? Of course not. It just goes somewhere else with fewer restrictions, with less transparency, and with participants who don't share our scruples. And if we continue down that road, it will be a lose-lose for everyone. It will be absolutely devastating for our cultural institutions, and I believe we'll even fail to achieve our other objectives. Our most effective tool in combating bad behavior and encouraging good behavior is the transparency afforded by a well-regulated, legitimate market. We actually have a good law on the books already that offers a template for achieving this, and it's high time we get after it.
Before we move on to the next speaker, let me just ask you one question. If, having suffered through the conference in New York or benefited from it, what one change legally would you like to see made that would make your life as a collector more certain, easier to manage?
What one change? Oh, gee, there are so many to choose from. I think the CCPIA offers an excellent set of guidelines. It's very clearly spelled out. And if we knew that that law was going to be implemented, actually according to the requirements of the law, it would make things a lot easier for collectors, museums alike.
Okay. Thank you. Who's up next? Mr. Potts.
Thank you, Tim. I'm going to start by saying I take it as pretty self-evident that museums are, or all things being equal, museums are a very good thing. They provide a safe home for important cultural material where they can be made accessible to the public, they can be studied, they can be researched, conserved, and preserved for the future. So they're important to scholarship, to education, and to society in general. The problem start to arise, though, from the fact that all things are not always equal. And it may be self-evident they're a good thing, but it becomes a moot point if museums cannot own things legally and ethically, however we're to define that, and hold them in their collections. And of course that is where the rub is in today's discussion, because that's the issue or that's the challenge that is being increasingly posed to museums in the current environment. Before I go on, I should have said right at the start, you probably know from the brochure, I'm with the Getty Museum, but what I'm going to say today is not representing the view of the museum or its trustees. I'm representing my own views as this is my 20th year as a museum director in four museums in 3 continents. So I'm drawing on that experience and my background as an archaeologist in the trenches, and I do mean trenches, not basements, and teaching and researching and so on. The core question, as it's sometimes put, is who can or should own antiquities. Now, the can suggests the legal dimension of this issue, and in a sense that's the simple answer to the can. That's the more definable one. There are all legal uncertainties, of course, they're complex, but in principle, the can is a legal matter. The should, on the other hand, is a much more philosophical and brings into us in contact with all the moral issues that surround the different points of view. There's also a third layer of consideration here that stems from the should question, and that is what are, in the real world that we live in, what are the effects of collecting? What are the consequences of, whether it's a private individual but also museums, of bringing these things into our collections? And in particular, the elephant is the nexus between collecting and the ongoing looting of archaeological sites, which is a real problem, and so is a very real issue and is appropriately the center of a lot of the discussion about what are the policies that museums should adopt. The only good news is that this is an empirical issue. This is a question of fact, of what causes what. It's measurable, it is to some extent definable, and we can look at the history of what has happened over the recent years and decades in coming to a view on that. So there are these 3 layers. There's the more philosophical or moral, there's the legal, and then there's the real-world consequences. And I think it's that complexity that makes this both a very interesting issue, but also a very difficult one and a complex one. And the discussions of these issues often vacillate between those different dimensions of the issue without being quite clear that they're doing so. And it can, I think, be therefore somewhat confusing. And I at least will try in what I say to be clear when I am, which level I'm operating at in my comments. On the philosophical level of the question of who should own antiquities or ancient cultural property, just to reiterate what will be familiar to many of you, I think John Merriman's distinction is still a valid one. There's the broadly internationalist perspective, which is that through history, looking historically, works of art, and including ancient works, have moved, been owned privately, have been exchanged, moved between cultures, and then indeed this is part of art history itself. The European art history and indeed Middle Eastern and other cultures would not be what they were if these works had not been owned, moved through good reasons and bad, through wars, through pillage, as well as through just normal ownership and exchange. But they are part of the history of the archaeological record and indeed of the art historical record. And that in the modern age, I'm expressing the view, the sort of Merriman perspective, that this has been, the fact that museums can collect and own these things from different cultures provides the basis for understanding other cultures, therefore for tolerance, and a deeper appreciation of the complexity of our own culture and of others, and that these are all good things. Likewise, having them in public institutions makes them accessible for study, research, and so on. The nationalist perspective is the one which typically vests ownership of these things in the modern state and puts variously severe restrictions on the movement of works outside that territory. So the idea is that these things should, in the moral, in the, if you like, yes, in the moral perspective, that's where they belong. And there is a special identity between the people of that nation state and that cultural heritage, and in a sense that underpins that sense of why it belongs there and why it should be there and even return there through restitution if it has been removed in the past. So how are we to begin to think about these issues? How do we work our way through this question? The first thing I'd say is this is resolutely a, if you like, philosophical debate. It comes down in a very real sense to what kind of culture we want to promote, what kind of world we want to live in. And it certainly does get you into the moral debate about moral and ethical, a debate about what is good for society, education, for individuals, for our own sense of a shared or perhaps not so shared cultural heritage. It also raises certain factual questions about this identity or supposed identity, because there are countries in which there's a clear historical, ethnic, and every other sort of link from the present day to the ancient cultures we're talking about. There's others where that link is much more tenuous. There have been invasions and dramatic ruptures in culture, and where the link, as it were, that identity is much more questionable. But the main point I want to reinforce is that it is no answer to this question, and it's not even really relevant to it, to say, well, let's look at what the law says. Because the law, from country to country, from jurisdiction to jurisdiction, is all over the place. There is no such thing as the legal view of what it's ethical or appropriate to do. There are radically contradictory laws between countries, between the US and certain other countries, but within the source countries themselves. Some of them have export prohibitions, some have blanket ownership provisions of everything in the ground, others have ownership of what was in the ground up beyond a certain date. So it isn't an answer to this question to say just follow the law. In a sense, that is to resign. That's a resignation of taking an ethical position, because you're really saying anything goes, just do what's appropriate in that jurisdiction and you won't get into trouble. And of course, we do all follow the law and should all follow the law. That's a given. I didn't bother to say that. I hope it's understood. That's what we in museums must and do. But don't kid yourself that by following the law you've somehow answered the ethical issues. You have not. The most extreme, we actually live in a country which is at one extreme of the spectrum. You can own essentially anything you own in this country you can export, except for there are categories of Native American material depending on where it was found. But by and large, America has a fully open, if you like, market in cultural property. It now restricts what can come in, but if you own it in this country, you're perfectly at liberty to take it out, to sell it, to do essentially what you will with it, and to sell it to a friend in Italy, in Central America, wherever. At the other extreme, of course, are the source countries, which limit dramatically what can leave their countries. I think one, just to illustrate, not with an ancient example, but to illustrate how different these conceptions of what it's appropriate to own can be, is the case that a previous director of the Guggenheim, I remember explaining that Peggy Guggenheim, of course, who lived part of her life in Italy and had part of her collection there of largely American painters of the mid-20th century, abstract expressionists, Pollock, Rothko, and so on, in her home in Italy. She left it to the Guggenheim Foundation, and when she died, the foundation decided they'd like to show some of the work here in America, in the Guggenheim. No, they were told, this is Italian patrimony. It cannot leave the country. So American art, made by Americans, by being in Italy for a number of years, had become part of Italian patrimony. So it seems rather ridiculous, frankly, but that's the world we actually live in. So the point is, what makes something, to generalize the point, what makes something illicit or looted in archaeological terms is not intrinsic to that object, nor even to how it was excavated or where or when. It's an issue of where the act happened. From jurisdiction to jurisdiction, the very same object, a Roman object excavated in Britain, and the very same object, if it were excavated in Italy, one is illicit, the other is not. In Britain, if you report it and so on, we have legislation which allows you to report and take ownership of that object. It is not an illicit object. The very same object excavated in Italy is illicit and cannot be legally owned. So let's now move on to the nexus, as I said, between looting and collecting, because that is the key issue where the desire to be ethical really gets traction. It's theoretically separate from the question of which philosophy you buy into, internationalist or nationalist, but in practice, The internationalists tend to downplay the implications for looting, and the nationalists tend to emphasize the connection with looting, as I think we would expect. And this is also the issue, I should add, where the museums in the development of policy over the last decade or two has been very much center stage. Museums don't want to be incentivizing further looting of ancient sites. So what sort of policy would ensure that acquisitions won't inspire further looting, or at least reduces that risk to an acceptable level? The policies we've had, and I'm speaking of the Association of Art Museum Directors, of which Tim Rubb is the current president. Before 2004, essentially it was a matter of use your discretion, be responsible, but it wasn't clear what, in a sense, how that discretion ought to be implemented. In 2004, we introduced a year of 10 years of provenance outside the source country, rolling 10 years. So that if something had been out of its source country for 10 years, it could be acquired by a museum. In 2008, we introduced the red line, as it's called, of 1970. So provenance has to go back to 1970 to be acceptable for purchase by a museum or receipt as a gift. And in that regard, I might, as a footnote, just say I'm not sure I agree entirely with Tim about the orphans being a problem that was introduced in 2008, because the 10-year rule did, in a sense, solve the orphan problem, because after that period of time, they could be acquired. So it was because we changed from a rolling 10 years to a firm line that there now are the orphans who will never be eligible for acquisition by a museum in a way that wasn't the case before. Now, there may be other problems with the 10-year rule, but as one merit it had, at least of those who worry about the orphan problem, was that it did provide some sort of solution to that. The orphan problem now, which is, of course, in a sense, the key one that a lot of us are focusing on, is central. And I have to say, I don't think there's any perfect solution. It is going to have to be a trade-off. The more scope you provide for museums to provide homes for orphans, the more risk, in theory, there is that you're incentivizing further looting. And the stronger stand against incentivizing looting that you take, the less your ability to give homes to these orphans in museums. So it is a question of what is the right balance, and I don't have any magic answer for it today. Second point I'd make is that 1970 was adopted on the assumption that it would safeguard objects that had come into collections in museums before 1970. And that really hasn't been the case. I think perhaps that was a misplaced assumption in the first place, because 1970 was never going to be a legal threshold, and it isn't a legal threshold. It's the memoranda have their own dates. Memoranda of understandings have their own dates, and they are legal thresholds, but 1970 doesn't have legal authority. It's a moral guideline. And claims continue to come in for objects well before 1970, in fact, some back to the 19th century. Third point I'd make is that 1970 is, to be quite obvious, an arbitrary line. It has no particular or intrinsic ethical weight to it. Why should something that came out in 1969 be okay to acquire, but something in 1971 not? There's no absolute magic to it. I think those who advocate it make the point, which is, I think, true, that its importance lies in the fact that it is a fixed line. There needs to be somewhere where you say, after this date, it's not okay to acquire. And that has been, I think, the force of the 1970 argument. There's no proof, however, that 1970 is far enough back to reduce the incentive to further looting to zero or to a low enough number. It's just assumed that that is the case, but in fact we have no evidence for it. I don't know how you'd begin to amass evidence for it. And of course it's no protection against legal claims against objects. As I was saying before, you can have owned something since 1950. If there's a claim from a patrimony law that was earlier than that, it's still, in principle, open to restitution. So the 1970 rule, and indeed all the CPIA provisions, are increasingly irrelevant in the context of claims being made on the basis of the National Stolen Property Act. And I won't go say anything more about that because there are more lawyers in the room who would be, I'm sure I'd say something that wasn't right and I'd hear all about it. Another point I'd make is that unilateral action, which the US is often in the position of making, hasn't, in my view, been as effective as we would have liked it to be. US museums have never been really major players in the market. They've bought very high-profile things, some of which have been very valuable. But in the numbers we've acquired have been, part of, but not the major part of the market for these things. And the further reduction in buying, which has been dramatic in the years since these new policies have come into place, don't, to the extent I'm aware, show any dramatic shift in the market as a whole. It's moved it to other parts of the world. We know of areas which are very actively collecting antiquities, but the market hasn't diminished. It's where that market is taking place that has shifted. Fifthly, the major incentive to looting in a number of source countries is, as has been pointed out, in their own internal legal markets in antiquities. There are countries where we have memoranda preventing material coming into this country, but it's perfectly legal for that material to be bought, sold, owned within the country. So there's thriving markets internally. So it just stands to reason that if there's an incentive which is driving the looting of those sites, it's much more likely to be the flourishing internal markets than it is what's happening overseas. Yet we are, at their request of some of these countries, preventing the import of this same material to the US, despite the fact that their blanket patrimony laws are philosophically very diverge dramatically from our own cultural policies and practices. And an example, to put this not in context, but perhaps an analogy, we are taking the view that the ownership, these blanket ownership provisions represent ownership in a straightforward and comparable way to the definition of ownership we apply to material within this country. Imagine a country with a very different view of free speech and censorship, where Rushdie's Satanic Verses is banned. You're not allowed to own it, not allowed to possess it. If someone from that country arrives in the United States with the Satanic Verses in their suitcase, we don't confiscate that object. We don't apply, because it was illegal for them to own it in that country, we don't buy into that view of censorship in this country. We don't apply that law. Yet, essentially, that's what we're doing with cultural property. We're saying whatever the law of ownership in another country with antiquities, we'll apply it in this country too. I'd also mention the fact that sometimes doesn't get remarked upon, that we can't, again, the evidence, I wish we had better evidence, but a lot of the new material that comes to light is from, if you like, accidental discovery rather than conscious and hardcore looting. A lot of it comes from road building, from urban sprawl, just the massive amount of earth that gets moved through processes all over the world in countries where there is archaeologically rich. A huge amount of material is accidentally discovered, which is itself unfortunate because the contexts are likewise lost and often destroyed on a massive scale. So it's highly regrettable, but it's not intentional looting in the sense that the Tumbaroli who go out and dig in Italy were. And a lot of the material, and I would estimate the vast majority of material, is of this character. So in thinking about what do we do to stem looting, we need to think about stemming what is actual looting and not just material which is coming up accidentally. That's not going to stop. There will be urban sprawl development. There will be construction of dams, roads, and so on. That material will be exposed in circumstances we're unhappy with, but it will happen. What's to happen to that material? And for what is the real looting, and that is continuing and is highly regrettable, I'd make the point that I don't think there's any substitute for on-the-ground, on-site policing of those sites. None of the attempts to stem the looting purely by constricting demand have been successful. The major breakdowns of real looting in places like Iraq and Syria have all happened where there's been a breakdown of central security. In Iraq under Saddam, as terrible as he was, it was a police state. The sites were not being looted. It was when the regime broke down and it was a free-for-all. Then, of course, it all started happening on a monumental scale, and we've seen the effects. And remember, a lot of this is if you like, these are very poor cultures, and people will dig things up if they can get the equivalent of $1 for them. You don't have to be, it's not a matter of there being a market of hundreds of thousands or millions. The looting will happen at that subsistence level for very small amounts of money. And as I say, there's no effective way to stop this happening other than effective policing of the sites. And if we're going to put funding into, if we're really serious about protecting sites, we have to put serious funding into the management of the important sites on the ground. The restitution, which may be important for other reasons, but don't kid yourself that restitution is doing anything about looting. Restitution is too little too late. You don't recover the context. You can never put the object back in the ground. The information isn't recovered through restitution. It's just the object goes back to a place, it's now held in a different place. And there may be good reasons for that, case by case. There are good reasons for that. But don't kid yourself we're doing anything about looting through that mechanism itself. I'd like to finish by just very quickly running through, I have a few moments, what is the world I would like to see us getting to. First, I'd like to see the US articulating a policy on ancient cultural heritage that can inform and guide the implementation of US law enforcement. And in fact, I think we have that. As others have said, the CPIA was a broadly internationalist perspective, but tempered with appropriate US contributions to prevent the looting of sites, and but it was a balance between the different perspectives. So I think something like the CPIA as the framework for a policy is the right one for the US to be basing its efforts upon. This same philosophical position should inform our decisions on which foreign patrimony laws we choose to enforce in this country. There's no question any country has the right to declare its ownership of whatever it declares ownership of. We do, however, have a choice as to which of those laws we decide mesh with the philosophical position this country takes and therefore ought to be implemented by law enforcement officers in this country. And there's not that is not part of the dialogue or matrix of decision-making that is currently in place. And of course, this gets into the fraught area of the CPIA versus NSPA provisions, which, as I say, I won't go into, but it would, to do that would require, of course, a resolution of that issue, one way or the other. I'd like to see us encouraging source countries to adopt other models that have been proven effective in preserving cultural property. The British system has worked very well. The reporting, when accidental discoveries are made, they are a very high proportion of them are being reported. The materials being registered, and museums have an opportunity to buy them. If they don't, there are ways the discoverer has rights as well and can take ownership of them. But it's been very successful as a model of preserving the archaeological heritage there. Japan's another system, has many admirers, where they rank objects in terms of the importance, and very certain high-level objects cannot leave, but others can go through a review and are able to leave the country. I think we need some line to be drawn to create safe harbor for material already in US collections, whether it's 1970 or 1983 or whatever, but there does, as other people have said, need to be some clarity so that we know we own and legitimately own material up to, that it was acquired up to that point. And this has to be a legal line. It's not just, as I say, extending the ethical dimension. It has to be, in some sense, a line trustees and directors can rely on from a legal point of view. I would hope, as I'm sure we all do, that future imports can be regulated according to a faithful implementation of the CPIA, the Cultural Property Implementation Act. I'd hope that some solution to the orphan problem can be negotiated with source countries. This is the hard one from where we currently stand with the 1970 rule. And as I say, I don't think there's a magic solution which keeps everyone happy. There'll have to be some compromise, some form of balance. More focus on site protection, as I was saying before. More focus also on persuading, and through negotiation, persuading the source countries to pull back on the state-sponsored destruction of cultural property. What is often not recognized is that hundreds, even thousands of sites are sometimes destroyed through the constructions of dams and other major public works. Now, for good reasons, these dams are being built, agriculture, the interests of their people. But these nations are making a decision that these economic needs or whatever are more important than the preservation of these sites. And it dwarfs what's happening through individual tomb robbers and so on. You know, massive destruction of cultural properties happening in source countries by the governments. And I think we need to play a role in persuading them that culture is more important than that. I would hope that some of the source countries can also be encouraged to develop their own collections on a more internationalist basis. You know, there's no reason why Latin American countries, Asian countries, and others shouldn't be collecting American art, European art, all these things, to the extent that it's possible to do so. And of course, some of them are doing it, notably in the Gulf. If we can do all this, if museums can again be seen as oases of culture and safe harbors for the important cultural and artistic heritage of the world, where they can be cared for and looked after more appropriately than anywhere else, I think we'll continue to make a great contribution to society. And frankly, unless museums are the entities that do these things, who else is going to play this role? Thank you.
Thank you, Tim. Kate, I think you're up next.
Michael? Me?
You're-
Okay. You know what? I'm feeling rather short. So I'm going to, if I may I use the podium?
Use a
Because
microphone
I
wherever
can't
it
see
is.
these folks, and I think they probably can't see me.
That's fine.
Okay, is this mic on?
Yes.
And could I also, as a housekeeping measure, I don't know if any of you have written down questions yet, but if Miriam is ready to, if you want to raise your hand and bring any over. You want to grab them? Well, we each have a piece of the puzzle here. And I have to say how tremendously important it is, how valuable for all of us it is to have the contribution of the museum representatives, even speaking as individuals, as for themselves, to this discussion, to this conversation. And it's essential that we take this into consideration. At Cardozo, we mostly dealt with legal issues, and the piece of the puzzle that I was given today was to talk about reform of the Cultural Property Implementation Act. And the first thing I'd like to say is that we don't need to reform the Cultural Property Implementation Act. The law in itself is just fine. Significant problems do arise because it's not the exclusive law governing the importation of cultural property due to the conflict between the NSPA and the CCPIA. There's an overlap that requires modifying the NSPA to conform with the policy set with Congress for cultural property in the 1983 Cultural Property Implementation Act, in my opinion. The problem that I have is with something else that I will call not the Cultural Property Implementation Act, which is the administrative process that results in agreements so far between the United States and 15 other nations, including, by the way, pretty much every ancient cradle of Western and Eastern civilization. Right now, we have agreements with all of Central America and Peru. We have agreements with Greece and Italy. We have an agreement with China. And we may, in a few months, have an agreement with Egypt. My issues are with the administration of the Cultural Property Act in a way that is really unrecognizable to me when I look at the actual text of the act or the Senate report that accompanied it. Those are the texts that I brought with me when I was appointed to the Cultural Property Advisory Committee in 2000. At the time, I was a textile expert, embroidery and ikat. And I was honored to accept a place on the committee. I felt great respect for the job that I'd been given and for the whole idea of making the law real, giving it effect. But after sitting with the other members of the committee behind the closed doors at the State Department, I came to feel that the law was dishonored there. I was inspired to leave the art world and become a member of one of America's best-loved professions. I became a lawyer. So I'm still here, much older, and trying to give this law a chance. The CCPIA, the real one, would be a perfectly good law, properly administered. Unfortunately, the knee-jerk response to source country requests has been so extreme that no other country has joined the United States in implementing similar import restrictions. And as others have pointed out today, unless we are working together with other countries, unless we look to the requirement for a concerted international effort in the Act, all we are doing is pushing the problem around. Law it's a remedy, okay? It's a kind of social medicine. It's a prescription that says, if you follow these instructions, you will do better as an individual, society will function, international relations will work. Congress saw a looting problem that needed to be rectified. Congress created a law that contained a diagnostic tool, which set forth these remedies. The problem is that the State Department appears to have ignored the analysis, the diagnosis that Congress required. It's ignored the criteria for applying remedies and just gone ahead and given a one-size-fits-all maximum dose prescription of embargoes on all art. And because it's applying a remedy that Congress said would work in a specific situation only, when other market countries would also sign on, when the source country would commit to self-help, and because it gives an overdose of embargo to every country that asks for a prescription, the remedy not only does not work properly, it often damages one or both of the patients, either the source country or the United States, or both. The State Department seems to have bought into two very political ideas, encouraging the idea that every object, without exception, is a cultural treasure necessary to each source country's national identity, and encouraging a prohibitionist perspective in which every aspect of the art trade in the United States is somehow tainted, either by looting or by colonial exploitation. And this encourages a lot of inflammatory rhetoric, and runs completely counter to the ideas behind the 1983 Act, that there would continue to be a flow of art to invigorate the U.S. museum system and U.S. cultural life. I'm going to take just one example. The United States agreement with China, which was renewed for 5 years back in last January. It's a really great example of an embargo that was established in defiance of every legal criteria required by Congress. And the result of U.S. import restrictions, pure and simple, has been to protect China's monopoly on the sale of Chinese art. The law requires that a country's cultural patrimony be in jeopardy from pillage. Well, the Chinese agreement is not limited to just areas where a specific type of art can be shown to have been looted. It goes from 75,000 BC to AD 907, and in the case of certain types of objects, wall art, monumental sculpture, it goes up to 1750 AD. The CCPIA requires that a country undertake self-help measures to protect its own cultural treasures, and the opposite has happened. While the U.S. market for Chinese art has dropped by half, China is the world's largest market for Chinese art. It's gone from zero, because China didn't used to, we remember what China was like. In the last 10 years, from virtually zero to nearly $1 billion in reported trade by just one major auction company, the Beijing Poly International Auction, which had nearly a $1 billion trade in 2012. And Beijing Poly International Auction, if you're not familiar with that name, it doesn't really ring a bell like Sotheby's or Christie's. It's the Chinese government commercial arm of the People's Liberation Army. Chinese museums continue to collect prohibited antiquities. Is that a self-help action? The law requires that agreements which are enacted in concert with other nations would be of substantial benefit in deterring a serious situation of pillage. Well, no other nation has comparable import restrictions to those of the United States on the import of art and artifacts from China. How can a U.S. embargo have real meaning when the largest market is in the source country itself? The CCPIA requires that import restrictions be consistent with the general interest of the international community in the exchange of cultural property. Instead, what the MOU with China does is it prevents U.S. citizens and U.S. institutions from acquiring the same objects that are freely traded in China and exported through free ports to other nations. Agreements are reviewed every 5 years, but the reviews must be very cursory. We've had one agreement with Guatemala now for, I think, 23 years. Is it working? Has anyone in Guatemala but the Ministry of Culture heard of it? And if you want to ask me about Guatemala, I can go on for a long time about that, but I won't do that right now. Looking back, I have a very hard time understanding how any agreement that has been established under the CCPIA actually meets the statute. The most common failure is the failure to require a concerted effort by other nations who are also in the market. And this is distressing because we have taken the most powerful and important piece of legislation on cultural property in the world, and we've turned it into a diplomatic Band-Aid for source countries. The way we use it is damaging U.S. interests, and I believe it's damaging U.S. museums. It's a good law, and I think we should try it sometime. I don't want to take more time. I want to let Michael and...
Okay, thank you. I suspect that your remarks are going to generate a lot of questions from the audience, but we'll take them later.
Is it me? I think, I don't care.
You forced me to choose.
Go ahead.
Yeah,
You
don't
go.
fight
Okay. Thank you. I'll be quick here. So I first became involved in cultural property issues during law school, and so naturally I've always approached these issues from the perspective of a legal academic. And my perspective is a bit unusual, I suppose, because I don't really have a stake in the game here, and I don't really have strong policy views about what the legal framework ought to be. Instead, my primary focus here has been on rule of law issues, specifically whether the laws, whatever they are properly administered and internally consistent. And so without getting too technical here, I'd just like to talk about some of these legal issues because they've been referenced here, but we'll try and get into some of the details. So first, are the cultural property laws being properly administered? In 2011, my mentor, Stephen Uris, and I co-authored an article in the Rutgers Law Review in which we identified 3 general areas in which the executive branch appeared to be overreaching or going beyond what the legal framework allowed as far as cultural property matters. So first, we addressed civil forfeiture complaints that were purportedly based on the McLean and Schultz decisions. These are very famous key decisions that generally held that a foreign nation's declaration of ownership coupled with illegal export from that nation rendered an object stolen for purposes of the National Stolen Property Act, or NSPA, which is the federal criminal theft statute in the United States. The government is also able to, in addition to criminal prosecution is able to bring civil forfeiture actions against an object when there has been an underlying violation of the NSPA. But we identified some civil forfeiture actions in which the government's allegations appeared to go beyond what the McLean and Schultz decisions had authorized. Second, we identified instances in which a rather obscure provision of the Archaeological Resources Protection Act of 1979, or also called ARPA, was being used as sort of an alternative to McLean and Schultz, even though it was apparent to us that ARPA was intended to apply only to archaeological objects originating in the United States, not those originating abroad. And third, we speculated that the executive branch was enacting very broad import restrictions without strictly adhering to the very specific statutory criteria that Congress had prescribed in the Cultural Property Implementation Act. Notably, we were forced to speculate about this because there was a lack of transparency in the process leading up to these import restrictions, but the information that we did find suggested that the criteria were at the very least being diluted. So in addition to the proper administration of the laws, there's then the separate issue of whether the laws themselves are consistent with each other. And much has been written about that, specifically whether the NSPA as interpreted by McLean and Schultz is consistent with the CPIA. And Bill Pearlstein's white paper that just came out or is coming out discussed that at length. And in my view, his white paper makes a compelling case that these two federal statutes do conflict in some important respects, and I'll just briefly talk about a few of these. First, one can lawfully import an object under the CPIA, but at the same time violate the NSPA. Import restrictions under the CPIA apply prospectively from the date that they take effect, whereas the McLean doctrine interpreting the NSPA looks not to the date of any import restrictions, but rather to the date that the foreign nation declared ownership over the object, which in many cases may be decades earlier. So anything imported in that interim period, or even in cases where there are no import restrictions at all, would be lawful under the CPIA but potentially actionable under the NSPA. In addition, the CPIA, in addition to prescribing the statutory criteria for import restrictions, also contains a provision specifically addressing and prohibiting the importation of quote-unquote stolen cultural property. That provision is limited to site-specific property or property that has been previously documented or inventoried in the foreign country. The foreign patrimony laws enforced by the NSPA and McLean, however, are not so limited and typically encompass anything found in the ground, regardless of whether it has been documented or not. And so the result is that the McLean doctrine and the NSPA have effectively subsumed or eclipsed the CPIA's provision addressing stolen property. Next, the CPIA contains safe harbor provisions that exempt from forfeiture certain objects already in the United States. Generally speaking, these safe harbors are based on how long an object has been in the United States and the degree to which it has been published or exhibited. However, an object can be immune from forfeiture under these safe harbor provisions, yet still be subject to forfeiture and even prosecution under the NSPA. This is so because while the NSPA has a 5-year statute of limitations, it criminalizes possession, and possession is a continuous offense. Therefore, the statute of limitations will not start to run unless and until the possessor divests himself of the property, which often doesn't ever happen. And finally, the burdens of proof in civil forfeiture actions can be different. So in a civil forfeiture action based on the McLean theory and the NSPA, the government typically needs to show only probable cause to believe that the object is subject to forfeiture. And then if they do that, then that shifts the burden to the claimant to prove that the object is not subject to forfeiture, not stolen. However, under the CPIA's forfeiture provisions, which are seldom invoked given McLean and the availability of the NSPA, it is the government that has the full burden to prove that the object was stolen. So with that said, I guess there are two fairly difficult questions that arise. One, is there a problem? And if so, how should it be fixed? Now, going back to my non-policy academic perspective, my view is that first and foremost, the executive branch should be executing the laws as they exist, and whenever it fails to do that, even if unintentionally, then we have a bit of a separation of powers concern. To the extent that the executive finds the laws insufficient to accomplish its desired policy goals, it should ask Congress to change the laws, simple as that. As for the conflict in the laws, I find it a bit untenable, just as a matter of legislative coherence, to have two federal statutes addressing the same distinct issue in a contradictory manner. And that is particularly true, as we've heard here today, in an area such as this where there are numerous commercial transactions taking place, and where many of the actors really do want to comply with the laws but have a hard time understanding what the rules of the game are, and that leads to a lack of stability and finality in many instances. Now, assuming that there is a problem, what can be done? Now, in his white paper, Bill Pearlstein has proposed reviving a bill from the mid-1980s that would legislatively overrule McLean by limiting the NSPA to documented site-specific cultural objects, thereby bringing it in line with the CPIA's cultural stolen property provision. That proposal would indeed resolve a significant conflict in the laws. Realistically, whether that's practical, I am a little doubtful. I think it would generate a lot of fierce opposition, and the ship may have sailed on overruling McLean. We'll see. That said, there may be other less controversial options that could alleviate some of the issues that I mentioned. For example, Congress could, for one thing, seek to increase transparency with respect to the administration of the CPIA, facilitating greater scrutiny of the statutory criteria, but at the same time without revealing or jeopardizing truly sensitive information about the location of looting sites and things like that. Another example, Congress might also conform the burdens of proof in forfeiture actions, as there does not seem to be a justification for the difference that currently exists. And it might also consider adopting some sort of discovery rule for the NSPA statute of limitations to allow for at least some degree of repose. And these are just some examples. But by the way, change need not come from Congress alone. There was an interesting suggestion at the Cardozo Symposium that perhaps the Justice Department might consider adopting some internal guidelines for cultural property cases, which might possibly help ensure closer adherence to the McLean and Schultz decisions. Now, it may seem premature to even discuss these potential options for reform without first addressing whether the political will or interest actually exists to revisit these issues. I don't purport to know the answer to that, but I do believe that much has changed since Congress enacted the CPIA over 30 years ago, and that Congress, at least to my knowledge, has not been actively superintending this area of the law since that time. And so I think that at the very least, it would be beneficial for Congress to take a fresh look at this area, even if it were to ultimately conclude that no corrective action was necessary. But I believe that this event and events like this are a welcome step in that direction. Thank you.
Thank you. And finally, Mr. McCullough.
Good afternoon, ladies and gentlemen. I'm here today because 100% of my practice, my law practice, is dedicated towards the art market. I'm a partner in Pearlstein and McCullough. My partner, Bill Pearlstein, is the gentleman who's been referred to as the author of the white paper that was subject of the Cardozo conference a couple of weeks ago. And we represent clients who buy and sell everything from antiquities to contemporary art. And I'd like to step back just for a quick moment to give you a perspective on the art market in general, because I think it's important to this discussion. If you're an in-house lawyer at an auction house in the United States, it's a very busy time for you because the art market is under siege right now. The issues we're discussing today are not new, but there are two other areas of the art market that are being highly regulated right now. or at least there attempts to highly regulate these areas of the market, and it's a big concern. First and not most important, there was a bill introduced into Congress by Congressman Nadler to create a resale royalty for the sale of artwork in the United States. And the bill, if you take a look at it, applies to sales of artwork at auctions. It's a major concern because of the way the bill is drafted, but overall, what it does, it creates a regime where commissions would have to be paid to artists on the resale of their artwork. Now, that in and of itself is not a bad idea, but if you read the way the bill is drafted, it's very much directed at auctioneers only, so it cuts out the private market. And it also deals with a couple of other thorny issues that I'll leave aside for the moment. But second, and maybe more importantly, recently the U.S. Fish and Wildlife Service has reinterpreted the Endangered Species Act to basically shut down the market for decorative art in the United States that contains endangered species. So any decorative object that contains material like ivory, tortoiseshell, bone, coral, essentially cannot be sold in the United States unless it was recently imported and you have a copy of the import documents. Anything historically imported or anything made in the United States cannot be sold. There's about $1 billion worth of property in the United States that contains those materials. And that market is essentially shut down and those objects are worthless. So, if you step back, there's all of a sudden, for some reason, there's a tremendous amount of attention on the art market, and there's a tremendous amount of regulation and law coming into place. Now, let's move forward then. That's the step back. Let's move forward. We've heard some very excellent presentations, and I'm just going to try to add a few things to that's already been said. But I do think in the cultural property area, because we advise people who buy and sell, and we do this, I'm one of the few lawyers in the United States who does this on a daily basis. There are some others in the room here, but it's a big part of our practice. And Timothy mentioned the changing legal landscape and the lack of predictability, and I wholeheartedly agree with those observations. It's very difficult. These are very difficult legal issues for the reasons that Andrew and Kate mentioned, and it is extremely difficult for people who buy and sell to work in this market right now. So predictability is a huge problem. And it's a problem in any market. Markets being regulated is not a new issue. But the art market being regulated is complicated because overall, the regulating agencies, and I'm not going to, the State Department's been mentioned, there are other agencies involved with these other areas of the art market now, but generally speaking, the regulating agencies do not understand how the market works. And I think in the case of some of these regulating agencies, they don't believe that there should be a legitimate market in these types of materials. So you have a huge conflict between agencies that don't understand and really don't want to market in these materials and private buyers and sellers who want to create a licit market, but it's very difficult to apply the laws and the court decisions. So how do you solve this? Well, I have some ideas that I'll throw out. But in the interest of time, because I see that we have a half hour left, a little less than a half hour left, and many of you come to these events as much to speak as to listen. So let me be brief and give you two examples of how these issues play out. And I'll pick two recent cases because they're very instructive. The first case is a case called United States against Cooley, which was a case in the Eastern District of New York a couple of years ago. It involved an antiquities dealer named Cooley, who imported many objects that were misdeclared to the Customs Service. So we're talking about cultural property, we've already outlined three areas that I'll just reiterate quickly. First, if you're buying and selling cultural property, you have to be concerned with how the object was imported, because by definition, unless you're dealing with American Indian objects, they're all imported or were imported at some time. So how the object was imported is important. So just the mechanics, the documents, how they were declared. The second is the Cultural Property Implementation Act, which for certain types of objects that are defined, there's documentation requirements if it's imported after the Memorandum of Understanding is negotiated between U.S. and the foreign country. Okay? And then the third area, as has been mentioned, is the National Stolen Property Act, which asks the question: does the person selling or is the person selling the object an owner? Are they the true owner, or does the foreign government have an ownership claim to the object? So, the Cooley case was about declarations to customs, and there were misdeclarations by Cooley. What happened after that, though, is two other people were brought into the case. So what turned out to be a very simple misdeclaration case against an art dealer turned into a conspiracy case, which involved Joe Lewis, a collector who purchased an object from Mr. Cooley, and a coin dealer named Alstafat, who introduced Cooley to the seller of the object in the foreign country. So it went from foreign country to Cooley to Lewis. And there was a big splash at the time. This was a big case. And what happened was, one morning, Alstafat woke his four young girls under age 12 and his wife to find 30 ICE agents, Immigration and Customs Enforcement, which is the agency that regulates, enforces the customs laws. And there were 30 agents with machine guns that entered his home and took his four daughters under 12 and his wife to a room, segregated, and took him into another room and went through his house and found, he's a coin dealer, ancient coin dealer, they found ancient coins and objects. The same thing happened to Mr. Lewis. And what you didn't hear about that case is a year or so later, the charges against Mr. Lewis were dropped because there was not a conspiracy in this case. The charges against Mr. Alstafat were maintained, but he pled guilty to a sort of low-level misdemeanor, essentially to help his lawyers out and to just get this behind him. So the case, which was originally just an art dealer misdeclaring things, turned into a conspiracy, which turned back into really a case of just an art dealer misdeclaring things. And as a result, well, there are two results. Number one, a lot of lawyers made money. That was the first result of that case. Well, three results. The second thing is Mr. Cooley pled guilty to his, just to your point, the second result was that Mr. Cooley pled guilty. He received 1 year of probation. He had served, I think, 6 months of home detention, and he paid a fine. And the second outcome is there are 4 young girls under 12 years old who have nightmares every night about men coming in with machine guns to their house. So as a result, Mr. Alstafat moved to Canada, where his wife works. They're in Detroit. Moved to Canada to alleviate that problem. That's an example of how this plays out. So we've been hearing about sort of the theoretical arguments. And, Tim described 3 lanes: philosophical, legal, and practical. I don't swim the philosophical lane. I swim the legal and the practical lane. And practically speaking, a case like I just described is a very difficult case to deal with because the federal government has tremendous power to bring these cases. So Kate and Andrew had mentioned, revising the Department of Justice's guidelines for how cases are brought. I think that's a good idea. Let me mention the second case, and then I'll finish up. The second case is the case of the forfeiture case in the Southern District of New York that dealt with a Cambodian sculpture that was owned by a family in Europe and was being sold at Sotheby's. I call this one, if the first case I described was the case of the conspiracy that didn't exist, the second case is the case of the stolen property that didn't exist. Because the allegation in the forfeiture case was that this Cambodian sculpture was owned by Cambodia. Under our national stolen property, the Cambodian law that was identified gave Cambodia title to the object, and therefore it was forfeited by the U.S. government. Well, that's not the case. As a matter of fact, the case was settled and the object went back. But if you look at the case very closely, and the lawyers, the claimants were the owner and Sotheby's, and they did it, the lawyers did an excellent job of outlining how, under our national stolen property, there's no way that that object is stolen. It's not possible. Andrew and Kate mentioned the McLean and Schultz cases, and essentially, just to boil this down, in order for a foreign law, like the Cambodian law, to be enforced in the United States and render title on behalf of the foreign government, the law has to be clear, it has to be unambiguous, it has to be known, and it has to be enforced in the foreign country. And in that case, if I'm not mistaken, and I don't think I am, the law that was used was a law from colonial Indochina. I don't know how old it was. I think it's from the early part of the 20th century. And the law was discovered, I think, by an expert, a legal expert in French colonial law. Now, I'll be generous. I mean, maybe there's 100 people in the world that understand French colonial law, but I'll be generous. I'll say there are 1,000 people, just to make my point. Is it possible that a law known by 1,000 people on this planet, and I don't know how many zeros you need behind the one or in front of the one to figure out what percentage of the population that is, but the fact is that that's not a law that is either known, whether it's clear or unambiguous, I don't know. I didn't look at it closely, but it's certainly not known and certainly not enforced in Cambodia because the Cambodians didn't know about it. So when the US government went to Cambodia, now Cambodia has a modern law. Cambodia has a modern law. They have a modern ownership law that we would, but you could say it's clear, unambiguous, and known. And I'm sure the lawyers for the claimants knew that. I'm not sure, but I'm pretty confident that they're smart lawyers. They know what they're doing. Sotheby's and Christie's are companies that hire good lawyers. They know their stuff. They have resources. So, they knew about the modern law. What no one knew about, including the Cambodian government, is the colonial law. Yet this was the basis for the seizure. So, getting back to the predictability point and the point of hiring lawyers, the net result of the Cambodian sculpture case was the claimants probably spent somewhere around, I don't know, I'm guessing $1 million because they had a really good law firm with smart lawyers that charge a lot of money. And in the end, the piece went back. Why? Because what the judge said, and it's a really good decision to read, so if you haven't read it, Google it and find it and read it. It simply said that the judge was not required to make the determination of whether that law is enforceable under the National Stolen Property Act, because that's a defense at trial. So what was going on was a pre-trial motion, and the judge said, the case law, the Schultz and McLean cases and other cases, don't require me to determine this now. That's a defense at trial. We'll determine that later. Talk about predictability. These are really smart people who looked at an object and said, this is an object we can sell and import. The government turns around and says, no, you can't. It's owned by the foreign country. You spend $1 million to defend yourself to have a judge tell you, sorry, I can't help you unless you want to spend another couple $1 million. And the net result is an object that should have stayed here and could have been sold on the market went back. Now, I'm not talking about the philosophical, ethical part of this because I don't swim that lane. So there are other arguments why people think that object should have gone back. Legally, though, I see no reason why it should have, and quite frankly, I think it's a shame. So, what are the answers? Many answers have come up. Let me just spend, 1 minute, because it's getting late. We should have a bill introduced in Congress that does a few things. First, the bill should require that if a foreign country asks the U.S. to enforce their law, their ownership law in the United States, there should be a pretrial hearing to determine whether that law actually can be enforced under the Schultz and McLean doctrine. And by the way, we should probably take that Schultz and McLean doctrine, which is court law, and codify it, write it into the law, figure out what it should say. That would help. The second thing is we talked about the CPIA and NSPA. Those should be harmonized. I agree with Andrew and Kate. There should be some harmonization there. And the last thing that I think should be that doesn't need legislation is I think the private market should get together. Auctioneers, dealers, collectors should get together, have a conference, and at least, if we can't get a bill like that, determine which laws that the market believes are legitimate and enforceable foreign ownership laws, and then use that as a benchmark for the market So at least everyone who's in the market can agree these are laws we see that are enforceable laws, so we'll follow those laws. And then these are laws that we don't think can be enforced under our National Stop Property Act, and we won't enforce those. At least that will give the market some clarity. Thank you very much for listening.
Well, thank you, and thanks to all the panelists. Let's first, in the time we have remaining, swim in the political lane a bit, if we may. And I'm going to turn things back to Kate. I've got a question for you from the audience, but before I ask you about that, I want to ask want you to speak a bit about what, be ecumenical and what talk about what CPAC is doing well right now and should maintain or perhaps even do more of, and what are the key remedies in your opinion in terms of how CPAC's behaviors, decision making can be brought into conformance with the original purpose of the CPIA, and in a way that creates greater transparency or other outcomes you would wish for.
One of the caveats that I really need to express is that I haven't been on the committee itself since 2003, and the amount of information that comes out of the committee is so limited that it's difficult to do more than look at what we know goes in terms of the comments from museums and art dealers and so on, and the terms of the request. We don't know the justifications that support the restrictions that are implied. So from my recollection of sitting on the committee, I think the most important thing is to recognize that a threshold is a threshold and not a bump in the rug. That a few posters in an airport are not self-help measures. You know, that we ask source countries who are asking a great deal of us. They're asking us to conform our economy to their cultural property declarations. They're asking us to change a great deal, and when they ask that, I think there should be some give on the other side, and I think that in order to better the situation at the State Department, I think it's tremendously important that we shine a light, that we allow a little sunshine in, because right now, the only absolutely achievable goal that I can think of, that there's no good argument against, is that there should be transparency in the operation of our government. I've never heard of a committee that operated as secretly as the Cultural Property Advisory Committee. And there are reasons, in fact, that certain things should be kept secret. But I never saw a treasure map when I was in that committee.
Throw me a bone and tell the crowd what you think the CPAC does well on an ongoing basis.
You know, again, I'm not there right now.
No.
I think that CPAC does a real service to the nations of the world that are suffering from looting in providing a place for them to go and make a request. And I am saddened and distressed that of all the wealthy, developed countries that have received these restrictions, that there's only one in Africa.
So the question I have here kind of gets at the issue of what CPAC is there to do and how it balances, I think, competing aims. So it reads this as follows: with regard to the fact that the CPIA requires nations to implement self-help measures, what is your answer for a nation like Syria that does not have the capability to help itself? Should we not be implementing MOUs to protect Syrian heritage for the people of Syria at a time when they no longer have a voice or ability of their own?
I think that question is answered in the text of the Act to start with, that's where we have to go. We look to the law itself. And what the law says is when there can be a substantial amelioration of the looting situation by enactment of the Act, then we should do so. And we should collect data that shows how much Syrian material is actually coming into the United States. That's something that we can do with the help of U.S. Customs. We should be looking to in a situation like that, the problem is not really looting. The problem is howitzers, as Mark Wilson said in Cardozo, that when you have an ongoing civil conflict or a war, you're not going to be able to remedy through U.S. Customs law the spread of the dispersal of all the wealth in the country, which people are trying to get out as quickly as possible and take it anywhere they can. And you need to look to what we are able to do under the Act, the fact that other nations are not doing something. I would like to see CPAC going out and working with other countries, because the failure to have a really comprehensive response from the other nations is important. I saw a lot of stuff in Dubai and Abu Dhabi when I was there last, and I think that's one place where that stuff is going. So we need to be working with those people.
Okay, thank you. Let me turn to Tim Potts for a question that came from the floor about 1970. So I think that question will be with us for a long time. And the question reads as follows: the Getty was a leader in setting the 1970 date as an ethical benchmark. Why don't you change Getty guidelines to point in a better direction?
Well, there's an easy answer to that question, which is that would have to be the trustees that change it, not me.
Exactly. That's a good answer.
That's it. But I'd just point out historically, yes, it's true. The Getty brought in the 1970 rule before the AAMD did. So in that sense, it was the first, I think, to openly and publicly buy into that concept. Yeah.
Okay. Let me turn to Matt Polk here and ask a question that I find a bit confusing, but perhaps you can sort it through for me. In listening to this discussion, I've heard nothing about the major issues on illicit trade discussed in other spheres, such as the convergence of this criminal activity with other forms of illicit trade, i.e. the funding of WMDs with antiquities in Turkey in 2006. I have no idea what that is, but...
Well, and I'm not sure I'm qualified to answer it either, but as regards illicit trade, we all want it to stop. The question is, how do we reasonably go about doing that? I don't think that the United States can stop this on its own. It has to be a concerted international response. And I think this is one of our biggest hurdles, to try to get this sort of cooperation worldwide. A big part of it, I think, as well, is transparent, functioning markets. The more sunshine we have, the better able we will be to detect, genuine illicit activity. Now, as regards the possibility that trade in antiquities or other cultural property is being used to fund terrorism or as part of money laundering, actually, we have a gentleman right here in the audience who I think coined the term cultural racketeering. And so this is Jim McAndrew, formerly of Customs and Border Patrol, who founded the Fine Art Division. And I'll ask you, during your time of service, did you run across evidence that illicit trade in cultural property was being used to fund terrorism?
Well, let me just clarify my background. I was a senior special agent with the Department of Homeland Security, and I created and founded their art theft investigative program where it is today. I retired back in 2010 and now work for a law firm. One of the things that what I try to do and wanted to do is to show Homeland Security that, in fact, art trade, investigation for art is not just this little niche, little cute little area
was some semi-retired guy with 3 years left on the job to walk up and down Madison Avenue and visit the museums once in a while. That in fact, it had a broader connection to other investigative program areas. So the idea was to connect, see if I was able to connect ongoing federal investigations with art and money laundering, and art and weapons trafficking, and art and narcotics trafficking. So we were able to, and art, of course, in the support of terrorism, and we were able to, in a small space, able to connect art with narcotics trafficking. It's easy to do it in that realm. In money laundering, it's the same thing. The transfer of art became more obvious that, in fact, it was easy to smuggle out a painting or a little archaeological object that's worth $1 million and put it amongst your children's toys and walk out the border and guarantee some customs inspector in some foreign country or even the United States would never detect that piece as an archaeological piece. So that was away from money laundering. But when it comes to this comment of did the government established a connection with terrorism, the answer is absolutely not. And I'll say that for two reasons. Post 9/11, Homeland Security, who does 99% of the antiquity investigations, you got the FBI as an art crime team who consists of about 14 or 15 agents around the country. In Homeland Security, there's over 400 agents that do international art theft investigations. The lion's share, and because Homeland Security adopted the Customs Authority, Border Search Authority, and they're at the ports of entry, as a result, foreign countries requesting assistance, for the most part, came to Customs. You see in the news constantly, Customs and ICE, Immigration and Customs Enforcement, where I came from, continuously put out press releases of their successes, and very proudly so. That being said, it was well documented and stated, and firmly by Homeland Security in post 9/11 that you are not allowed to work terrorism cases. Matter of fact, the only agency that was able to work terrorism cases was the FBI. And if any federal agency, any federal agent, any other agency came across in any of their investigations, it could be an IRS investigation, it could be a fraud investigation with wearing apparel, but if you establish some connectivity to an insurgent group or a terrorist group, you must refer that investigation to the FBI. And I don't think that's changed. So the FBI, if there were any cases, and the FBI uses the press just as well as Homeland Security does. I've never once ever seen, even till today, one press release saved by the FBI that they have, in fact, connected the dots and made a successful criminal investigation that relates cultural property with the support of terror. Now what happens, what's gone askew over the years between all this, because you have all the civil unrest in Syria, in the war in Iraq, and in Libya, you always have two sides. You have civil unrest. You have these factions. So the faction that the U.S. government doesn't side with becomes, quote unquote, the bad guys, the insurgents. So that word gets tossed around fairly loosely, but that doesn't necessarily mean the sides that we don't side with are terrorists. Al-Qaeda is a different story, but I have not yet even seen in that realm a criminal case brought upon where terrorism and criminal case and cultural property were successfully convicted and publicized by I'll say by the FBI at this stage. Because Homeland Security could not work those cases. So all this talk, I don't think is real.
Well,
okay.
Thank you.
Thank you. A definitive statement. So let me put a question to the panel as a whole and begin with a statement that in many of these conversations we often run the risk of losing sight of what our desired long-term outcomes are. And for museums, clearly this is about continuing to foster the study of works of the artistic production of humankind and sharing that information and great works of art from all civilizations and all periods of time with the public. That I would stipulate requires us to continue to advocate for the free exchange, to facilitate the free exchange of works of art across national boundaries, and to advocate for illicit or legal market for doing so. We also have to think about the development of new mechanisms to foster the study and display of works of art, long-term loan agreements, sharing agreements of various types, and the like. So you can't consider one, in my opinion, without the other in this day and age. And having heard a lot about the legal mechanisms that are in place, what they are and how they work or don't work, the question that comes to my mind, again as a practitioner, is whether or not we have developed in concert with those legal mechanisms, however imperfect they are in concept or in implementation, the political and diplomatic tools today to achieve the goals that I've just outlined for museums and for the art market in the United States. And for me, that's a very, very big question I'd like you to touch on if you could a bit.
Yeah, that's an excellent question. What we lack in this country is a coherent policy because we lack one central place within the government that makes decisions on cultural policy. So what we need is a Bureau of Culture. And if we put that, I don't think we can have a ministry like other countries.
I didn't hear the applause meter rise very much for that.
Didn't.
Yeah.
You could try again if you'd like. But if we had a bureau within the Department of Interior, I think if we had a bureau of, well, I wouldn't put it elsewhere, but you know, if we had a Bureau of Culture, then we could decide, all of these issues we're talking about could be decided. And, you know, let me back up one second. Everyone here agrees that looting is a problem. I defend the market, but at the same time, I don't defend illegal activity. So if someone's breaking the law, they need to be punished. At the same time, if you have very smart people who understand the issues and can't figure out the law, there's a problem. Now, the ministry or the Bureau of Culture solves that problem. If there's one thing I could do, it would be that. Maybe you don't like where I put it, but that would be a good start.
Tim, you want to take a crack at that?
I mean, the diplomacy, there's no end. I mean, of course, it's a critical part of it. In a sense, there's no end to it, though. And it's not as if you solve it once and solve it for all time. It's an ongoing discussion. I think it's an area where clearly the more time and effort we can put into it, the better. Because the real solutions to these problems are not just us deciding what to do ourselves. It's got to be a collaboration. It's got to be multinational. But I think that's where I'll leave it.
Yeah. One of the issues that I discussed with Kate before this session started was that, in my view, looking over the long term and trying back over time and looking towards the future, political and legal restrictions in the flow of works of art across national boundaries are going to, I think, increase and become more difficult to navigate in the future. This is true in developed countries that have very highly effective, highly regulated and very highly effective systems for regulating works of art like Japan, Korea, England, France, and the like, as well as it is for countries that do not. And for me, the question, again, is how we continue to nourish our collections, but also our galleries and our conversations that we have with our visitors and audiences about what's out there and what's new, how it's changing the way we think about art history and the interaction of cultures over time and the like. And invariably, this leads us again to a conversation has many different sides to it. One is about the continued acquisition of works of art and their entry into our collection, our care for them. But the other is how we work with collectors and with source countries and other museums in other countries to continue to nurture our own work and enable us to do it in ways that it seems to me that it's going to be increasingly difficult to do simply in terms of acquisition. And herein, I think, lies the larger problem that we're dealing with. Again, the legal piece is a very important one, and it's obviously been well served by this conversation, but there are much larger issues, I think, at play here that are really important. Now, I think we have exceeded our hour, And I want to thank you for your time and ask you to thank our panelists for their time today as well.